May I request our panelists to please come on the stage. Dr. Gulshan, Director General, CERT-IN. Mr. Mukul Sharma, Advocate, Supreme Court of India. Mr. Faisal Farooqui, CEO, MouthShut.com. Dr. Raman, Mittal, Associate Professor, Faculty of Law, University of Delhi. And Mr. Ameet, Datta, Partner, Saikrishna and Associates. He is the moderator for this session. Mr. Ameet Datta.
Good evening. I'm Ameet Datta, and hopefully I'll be playing a very brief role as a moderator. I think the argument is an age-old argument: where my nose ends and where yours begins is the friction where our noses are not supposed to touch. And that's the age-old friction between our right to express ourselves, our right to commercial free speech, our right to dissent, and our obligation perhaps not to defame, not to cause outrages leading to public disorder, etc., etc. It's not really a mystery in terms of how courts in India have crystallized the law. The law has always been very forward-looking, very liberal, generously dipping into judicial precedent from across the world, America, England, and honoring the tradition, as democracies do, of preserving the right of free speech and balancing them with the imperatives that any republic or any organized democracy would have. Into this mix steps this hitherto an earlier unknown body called the Internet. And I remember an American lawyer telling me about one of the first engagements he had in outside of Cupertino with a client who was outraged about certain things written about his company. And they were hired to advise them on steps to be taken. And they had all sorts of recommendations. They were pretty happy. The billable hours were good. At the end of it, the client had one question and one demand. How do you switch the Internet off? I want you to switch it off, because it's, and this was the earlier perception. You had organizations called the Electronic Frontier Foundation, pretty much telling us how Wild West and lawless the Internet was deliciously supposed to be, and where the rule of law perhaps could not reach. And that has proved itself to be something else, hasn't it? We've looked at various attempts to balance both these competing interests, let me call it that. And I'm happy to tell you today we have a wide range of perspectives, and you wouldn't have these perspectives normally. You'd have either one side or perhaps two of the four or three or five sides, and happily we've got a lot of them. I'd like to introduce our panelists. I'd like to first introduce Mr. Mukul Sharma, who's an advocate to the Supreme Court and will enlighten us and will tell us about perspectives from a constitutional law issue where the Supreme Court has led the law and practice leading to how this friction is looked at to be sorted out. We have I don't think we have Mr. Gulshan Rai yet. Yep. We have Mr. Gulshan Rai, who will give us, he's not here. Mr. Gulshan Rai apparently had to leave. We have Mr. Faisal Farooqui, who's CEO of MouthShut.com, a well-known portal, and probably bears the burden of perhaps getting many of the takedown notices, facing a lot of litigation, and has stood the test of time until now. So it'll be interesting to get the business perspective from the perspective of business that's felt the sharp end of the stick, as it were. And we have the academic inference and support and perspective in the form of Dr. Raman Mittal, who's the Associate Professor, Faculty of Law at the University of Delhi. And I don't need to say more about Dr. Mittal. He's well known from the perspective of the academic appreciation of the law, the constitutional parameters around the Part 3 of the Constitution of India. What I'd like to do is request Mr. Mukul Sharma to give us a perspective and his appreciation of the so-called friction between our extant freedoms and this beast that we all call the internet. Mr. Mukul Sharma.
Ladies and gentlemen, with your permission, I shall be taking this lectern. It is a little difficult for me to be fully articulate while sitting down. Ladies and gentlemen, internet is the cutting edge of technology. It has been so for the last 15 years or so, and it is likely to remain so, shall we say, for a considerable time to come. At the same time, the freedom of speech and expression is a very remarkable right. And this very remarkable right and this cutting-edge technology have thrown up the questions which do not have easy answers. I will just try to discuss first as to what the freedom of speech and expression is, what it can do, and how it obtains in the society. This should be understood that the freedom of speech and expression is a rare virtue. It's a very precious development. Often, this is the last freedom to be conceded in any human society, and this freedom is the first to be taken away whenever, shall we say, that society is under any kind of stress. Those of us who are old enough to remember the events of, shall we say, 1975 and 1976, they will perhaps recall that when the emergency was imposed, the first right that was taken away was the right to freedom of speech and expression. And thereafter, so many unfortunate things happened, which probably would not have happened if this right were available. And I distinctly remember, although I was a student at that time, that when that emergency was lifted and the constitutional liberties were restored, there was a feeling of, I would say, there was a feeling which cannot easily be described. There was, so to speak, a loosening of the collar, loosening of a noose around one's throat. This was universally felt. It could not be articulated, but it was very much there. Again, I would say that the ultimate test of freedom of, ultimate test of the liberality and tolerance of any society, right from the tribal society up to the most complicated democracies, the ultimate test, the litmus test of liberality is the freedom of speech and expression. Dictators and despots have never conceded this right. The great constitutional documents, the Magna Carta, does not know it. The American Constitution literally, or rather literally overlooked it. But then they had their Bill of Rights, where this right was conceded. We borrowed upon the American Constitution, but we gave the freedom of speech and expression a very important position in our constitutional scheme. However, with the passage of time and with the experience that the framers of the Constitution had derived from their study and understanding of the working of freedom of speech and expression all over the world, they put it under several restraints. Those restraints have been judicially interpreted from time to time, and it has been observed that slowly and slowly, the ambit of freedom of speech and expression is being restricted. And it is being restricted in several very remarkable ways. Firstly, fundamental rights, including the right to freedom of speech and expression, is not a right which is available to a citizen as such against every other citizen. It is primarily a right available against the government, and again, it is a right to be safeguarded by the government if it has to remain effective for anyone. Again, to whom the freedom of speech and expression is really important? Obviously, it is important to us in a number of ways. This was articulated for the first time effectively in a constitutional bench decision, Menka Gandhi versus Union of India, which incidentally was a judgment that was delivered by the Supreme Court shortly after the emergency was over. Perhaps it would be recalled that during the emergency years, even the Supreme Court did suffer. There were many challenges to its authority. There were many challenges to its conventions. And it was not a happy time for the judiciary as for the lawyers as a whole. However, after the emergency was lifted, the experience, the painful experience of being in the state of deprivation of freedom of speech and expression was, shall we say, so much that the Supreme Court actually opened the door for a meaningful exercise of freedom of speech and expression, and the Supreme Court for the first time categorically realized that the freedom of speech and expression shall usher in a bundle of other rights, that is, the right to know, the right to research, the right to form opinion, as well as the right to have a civil discourse. The right to information is an offshoot from there. The right to privacy is also an offshoot from there. The right to take up a cause is also on account of the reason that the freedom of speech and expression has been broadened. However, there have been onslaughts also. The freedom of speech and expression is extremely important and is a very easily tolerated right when panegyrics are being sung to the politicians, to the administrators, even to the judges. The freedom of speech and expression becomes a little difficult to appreciate when some impertinent fellow gets up and begins to ask difficult questions. The freedom of speech and expression is very difficult to concede, shall we say, to the critics. However, till the beginning of this millennium, the freedom of speech and expression could be curtailed. The curtailment was that it was relatively easy to gag the press. It was relatively easy to interfere with the telephone lines. It was relatively easy to, shall we say, doctor the broadcasts. It was relatively easy to contain the dissemination of information. However, the internet absolutely changed everything. It gave, firstly, the reach which probably the print media did not have, which probably the electronic media did not have before, which obviously the press never had. The second thing was the internet gave anonymity. Any person writing anywhere at any point of time could say anything. Thirdly, the internet gave the reach. A single message, a single story could be broadcast all over the world without there being any effective check over it. Of course, it has its uses and misuses. And finally, the internet also made something very remarkably possible. The fact that once that something was put on the internet could not be erased or effaced. These properties of the internet have advantages as well as disadvantages. However, on the whole, the internet has become a life-changing system in our society, and it is good that it is continuing that way. However, it is a weapon, rather it's an instrument which can be used as an instrument for the greater good of the society. At the same time, it is also a very dangerous weapon because it is very easy for the terrorists, for the seditionists, as well as for those people who are trying to destabilize the societies or even to defame people in their individual capacity. Internet is a very powerful and potent medium, and there is probably no escape from it, and the laws which have been recently enacted to regulate and control are not really effective. In short, it would be observed that so far as the government action in India has been concerned, the government has been proactive in muzzling down the dissent. The government has yet to do something to really check the misuse of the internet, which is happening every day, and of which Justice Gyansudha Mishra gave you an example. I will leave out at this stage and allow some other person to address you further, and probably I will be able to come back.
Thank you, Mr. Sharma, for that very enlightening roundup of how the constitutional perspective developed. Since we are, kind of running short of time, can I quickly ask Dr. Raman Mittal to give us a quick perspective from the academic side on this on the subject of.
Yeah, good evening, everybody. I'm so happy to be here, especially finding so many of my students sitting in front of me. So I've been able to shake hands with some of them, but not with all of them. So I now propose a shake hand from here to those with whom I've not been able to do. Anyway, today I would like to do a critique of various provisions of the Information Technology Act which have a bearing on freedom of speech and expression, right? After the enlightening talk by Mr. Mukul Sharma about the basics of the importance of freedom of speech and expression in our constitution, in our lives. Now, in the 90s, John Gilmore, who was the co-founder of Electronic Frontier Foundation, made a statement. He said, and I quote, "Internet treats censorship as damage and roots around it." Meaning thereby, this is such a medium you cannot do anything about. You cannot censor it. Try, he said. He challenged. He said, you try, you will fail. We'll try to evaluate after about 2 decades. We will try to evaluate whether he was right or wrong. Another important personality of 90s was Professor John Perry Barlow of the Stanford and Harvard fame, who in 1996 wrote a letter addressed to the governments of the world saying that you weary giants of flesh and steel. Remember, he's addressing to the governments, not one government, governments of the world, that you weary giants of flesh and steel, you mind your own business. Don't touch. This is a new home, the new home of mind that we have created, the cyberspace, the internet. We will regulate it ourselves by social contract. There is no need for your laws. Don't mess with our new home of mind. Because he said that, well, lawmaking has a history of thousands of years. Like it's as old as the civilization. And what have we been able to achieve till now? The society remains in a mess. So don't create that mess out of the internet. Of course, there will be conflicts and we'll resolve them ourselves. So he was saying, John Gilmore said, you cannot censor internet. John Perry Barlow said, you should not. It is not desirable. John Gilmore said it is not possible. Now let's see what we have done in the Information Technology Act. I would like to read Section 66A, which is quite contentious these days. In brief, it says that anybody who spreads any information on the internet which is grossly offensive and has menacing character shall be punishable with an imprisonment and or fine, etc., etc. Like, now, what is grossly offensive? I'm addressing a gathering of lawyers. What is offensive? I say, I don't like you. I don't like your face. Is it not offensive? There is no definition. Now, we are all users of Facebook. We are all users of YouTube. To what conceivable extent offensive material is not there on these sites? Is anybody able to do anything? Hardly. But yes, the law is there. If you want to kick the ass of somebody, you can. And that has happened in the past. We very well know, just by liking a post which was not offensive, which to me it was not offensive, well, so a lady was apprehended, 2 ladies, right? Now, another very important part of internet architecture is the presence of intermediaries. Who is an intermediary? We all are users of the internet, but who takes us to the internet? Is there a possibility of a direct connection to the internet? That is not possible. On the internet architecture, an intermediary is must to take you there, is the boat which takes you there to the middle of the ocean, right, where internet is, or in any other ways we can describe it. So that is the importance of intermediary. Now, what should be their liability? Should they receive any exemption from liability, or they should have absolute liability? Now, should they be liable like publishers, like a newspaper publisher is, or should they be liable like the person who gives you the newspaper wala, or should they be liable as a postman of the internet, common carriers, like? So that kind of balance, we know they cannot be absolutely liable. Second, they cannot be left without liability. So what the balance is struck, law is the name of like striking balances. So the balance is struck in the form of legislation, which we call Section 79 of the Information Technology Act. Again, very, very contentious piece of legislation. Now, the very architecture, if we see, of Section 79 is that it is not making internet service providers or intermediaries liable for anything. It says, the title says, exemption from liability of internet service, of intermediaries in certain cases. So this section, this provision is meant only for giving exemptions and not making people liable. All right. Now, it is attached to any law. This Section 79 is attached to any law. That means if a liability arises under any law, it can be limited under Section 79 of the Information Technology Act. Now, it gives the liability, it gives exemption from liability or safe harbor, but it is not a blanket exemption. It is pegged on to two conditions. Those two conditions are due diligence and knowledge. All right. Now, the way this section is drafted, I would like to comment a little on the scheme, on the architecture, on the drafting of this provision, which to me seems to be a little faulty. Now, subsection 2 and 3 of Section 79, subsection 2 talks about due diligence and subsection 3 talks about knowledge. Now, first let me focus just on subsection 2. It has got three parts, A, B and C. At the end of part A, we find a OR. Do we find OR? Yes. At the end of part B, we find a semicolon and then a part C. What do you infer? Is there an OR between A and B only, or between C also? Do we read that semicolon as OR as AND, in short? If we read it as AND, let us say AND, then is subpart C attached to part A as well as part B, or only with part B? That's another problem. If we read it as OR, then we say it's either A or B or C. So if the intermediary satisfies any of these three, then he's out of the liability. So it depends on the reading, because both the readings are possible, right? So what is the right reading? Now we have to go to understand, like to appreciate the right reading, we must know the content of what are these provisions. Part A talks about that it tries to limit the liability if the function of the intermediary is limited to providing access only. See, intermediaries perform two parts of roles. One is just providing you access to the internet. Second is it also takes your information. It hosts. It stores your information, your data. So there's a clear categorization of intermediaries as we see in the legislation in Section 79. Now, if the person is only a common carrier, not hosting anything, then he has been given exemption in A, right? Similarly, B says, and there's an OR, please remember there's an OR between A and B. B says if the intermediary does not initiate the transmission or changes any content of the transmission in between, or does not choose the recipient of the transmission, then also he has no liability. Now in C comes due diligence. Do we expect just a carrier, just a postman who takes your data from A place to B place to be made liable? What kind of due diligence do we expect from him? See, what kind of data is he storing? Say, for example, MTNL. Let us say he's only MTNL, and there are smaller ISPs as well. The definition of ISP is huge, like very wide in, yeah, just 1 minute. So, I mean, we cannot burden that kind of just common carrier with a liability of due diligence. It's very difficult. What kind of due diligence can he do? Gigabytes of information is passing through his servers all the time. What kind of filters can he possibly implement? What are the filters? We don't know. Yes, we say that, yeah, pornography, there are filters, but then pornography is not the only thing. And that too, it's difficult to decide what is pornography and what is not. There are no definitions for that. Like, I would like to quote that American judge who said, well, for pornography, I know it when I see it. I can't describe it. Then there are copyright violations, there are trademark violations, there are trade secret violations on the internet. Do we know? Do we know of any filters which can filter all these things? We don't know. It's like, if we read it as AND, it is like taking the liability of intermediaries to the sheer limits of impracticality. Then the last point I would like to touch is the third, subsection 3 of section 79, which talks about knowledge. Now, knowledge says that upon receiving actual knowledge or upon being notified by a governmental authority or a private person, the ISP is supposed to take down the contentious matter. Now, what is this knowledge? Is it the knowledge of the presence of the material or the knowledge of the illegality of the material? Presence of the material can be notified very easily. I can say that, well, my song is on YouTube or any other website, please remove it, this is copyrighted to me. But how would the internet service provider, who may not be a very big one, may not be able to employ lawyers as specialists, how would he know, how would he judge that that content is that copyright infringing? So if we expect him to take down the material only on the request of any private person, that's like killing free speech as well. That's like tilting the balance towards taking it down rather than keeping it on. So if the choice is between keeping bad material on the internet and taking down good material on the internet, the legislation has chosen the balance to be towards taking down even the good material on the internet. So I don't have much time, so there are rules as well which are also quite debatable, their wording and their expressions used which are not defined anywhere. So, but I'd like to, I've stated the broad points, and thank you so much to the organizers for giving me the opportunity. Thank you.
Thank you, Dr. Mittal, for your very cautionary analysis of the potential problems with how the legislation has been framed. In fact, I believe the rules also are problematic that link to section 79 that talked about internal knowledge and knowledge accrued by yourself. So, I think that is something that, deserves to be looked at much closer. I think, one interesting aspect or one interesting perception is always delivered by the person who actually feels the heat. And there's nobody who's potentially felt the heat more, or rather competes with the people who feel the heat, is Mr. Faisal Farooqui of CEO MouthShut.com. I'm going to request, I'm so sorry, but we've got really little time. So just your brief perceptions. And don't blame lawyers completely.
Very good evening. When I first started MouthShut, I honestly did not know that I would be sitting with lawyers on a panel. And not just on a panel, but in a room full of lawyers. The feeling that I have right now, he's asked me to be brief. So I will sort of like summarize it in an Urdu couplet, a sher. I have very mixed feelings right now. A, because I'm in such august company, and B, because the subject is so vast that I'm not qualified to speak on this. The Urdu couplet that comes to my mind, and I'm not an academician for that matter, I just came to my mind, सुकूने दिल के लिए कुछ तो एहतमाम करूं और ज़रा नज़र जो मिले तो झुककर सलाम करूं मुझको तो होश नहीं आप ही कीजिए फैसला कहां से फसाना शुरू करूं कहां तमाम करूं we technology guys, we create problems. We create problems because we don't sleep at night. We don't sleep at night because we have an addiction to computers. And then we take care of everything in the morning by sleeping in the morning, and we end up in trouble. And we feel, obviously we feel scared of all the troubles that we have created. And for that sukoon-e-dil, we pass on the buck to the lawyers to take care of it. And that's why I said sukoon-e-dil ke liye kuch to ehtamam karoon, that I should do something formal for my sukoon-e-dil, aur zara nazar mile, aap jaise lawyers se mile, to jhukkar salam karoon. Mujhko to hosh nahi, aap hi kijiye faisla. You decide where should I start my story and where should I begin and end. I had never anticipated that we will be facing 260 legal notices by last count. I thought I was doing business. I thought I was being a cool geek. There was a movie which made geeks famous. 13 cases in various courts of India. In many of the cases, I don't even have a lawyer in that region. We claim that it's not in this jurisdiction that we operate. And more than 800 takedown notices. When I started MouthShut, I inspired a bunch of people to join me. And it was all about that in India, there was no platform where consumers could express their opinions on products and services. It was no more the country where only fiat was available. My father booked it in 1960, got it in 72. Now, there was a country where 254 different models of cars were available. So how do you decide which car? Fiat Linea says they're the best. Mercedes say they're the best. Volkswagen says they're the best. Everybody says they're the best. And Ambassador obviously claims they're the best. So we said, let's build a platform where people can express their opinions, good or bad. And not just on cars, not just on mobile phones, because it's no more just Nokia phones. There are 700 different mobile phones available. Not just on restaurants, because not just one restaurant out there. Not just on one hospital, because now everybody and their brother-in-law is starting a hospital. Not just on one TV channel, because now there are 300 different TV channels. We wanted people to express their views. And the Indian consumer was empowered with this data. And the Indian consumer said, fool me once, shame on you. He's telling the brand, fool me once, shame on you. Fool me twice, shame on me. You fooled me twice, I didn't learn from my previous mistake. Aap raat mein khana khaye, they had a bad service, the food wasn't good, you were still charged. What do? You fight with the manager says, nahi sir, aapko khana to de diya tha, you have to pay for it. 2,000 rupees, well, maybe for a lot of people, 2,000 rupees is not a lot of money, but for many of you, 2,000 rupees is a lot of money. Well, you make sure that you go to MouthShut.com and you write about it. And that's what happened. And this went on viral for 6 lakh product and services. On Saturday morning, if you read reviews on MouthShut.com, you can very well decide if you want to spend your evening watching that movie or not. Of your hard-earned money, of your time. So producers started worrying. शाम में तो मूवी रिलीज हुई, दूसरे दिन 16 रिव्यू आ गए, 15 नेगेटिव हैं. अब तो ये पेड रिव्यूअर्स का बिजनेस तो खत्म हो गया. So the official reviewer of Times of India was out of job. The official food critic was out of job. You are the reviewer. You are the critic. So what happened? They all got scared. Well, many internalized the fact that the world is changing. Many internalize the fact that dunya badal rahi hai and we have to learn to live with criticism. And we have to fix our product. And they started. But some still non-aggressive, they adopted the legal notice route. So one legal notice that came to me was from a builder in Pune. And the builder sent me a legal notice saying, there are 5 reviews on MouthShut, remove it. We did not remove it. We wrote to him that these are reviews written by your customers, people in Pune. You contact them, ask them to either remove it or you fix their issue. That's our standard, usual standard reply. So second notice we get, and I'm not exaggerating, and I'm not lying, 2,000 crores. Now the only figure I had ever heard of 2,000 crores was when I used to read Sahara's turnover and Sahara's balance sheets. Now somebody is asking me for 2,000 crores. I fell off the chair. I fell off the chair, I couldn't sleep that night. 5 reviews, 2,000 crores. I called up my lawyer friends, Sukoon-e-Dil. Said, kuch nahi hoega. Thank you. I ignored it. The guy started calling me. Thankfully, I don't have my mobile numbers published anywhere. Somehow they managed to speak to me. So I said, sir, you need to fix your problem. He said, my entire apartment complex is not selling because of those 5 reviews. And I realized, you know what? It's not selling because it's no more people in their 50s who are buying apartments. People in 20s and 30s who are now earning, thanks to ICICI, thanks to HDFC, they're getting a loan, they're saying, hey, I have the money, you have the apartment, I'll buy it. And now it's a buyer's market. So they go there, they say, this is not what you promised us for 45 lakh rupees. Well, he said, this is what you get. Now, the new generation, I'm sorry, but my older generation, my father, my grandfather, your father, some of you uncles in this are very nice people. But in my generation, people want instant result. They said, no, 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 you fix it. And the builder said, we can't fix it. And so they said, oh, you don't want to fix it? Fine, I'll go to MouthShut.com. The project never took off. I'm not to be blamed for it. There's a coaching class, JTS Institute. They may have cheated their students, they may have not cheated their students. I don't know. They asked us to remove the review. We said we're not removing. They sent us a big legal notice. There's an engineering college here in Gurgaon. Some students were dissatisfied. They were suspended. The students said it's not right. Well, they said, well, the college is the final authority. Students have paid money. Some have paid capitation fees of 5-6 lakh rupees. Some of their parents have borrowed money. Some of their parents have sold their jewelry to finance these education. And you're suspending them? I'm not getting into the issue. They sue MouthShut. They want damages of 2 crore rupees. There's a car manufacturer. They want all kinds of compensation. They don't want to fix their own problem. And my thing is, there is a law, Section 79, that requires them to send a notice to me to get it removed. I don't have the time to remove it because if I remove it, everything that I stand for, everything that MouthShut stands for your words, for your ideas, for your stories, it gets nullified. So you know what we've done? We've challenged Section 79 in the Supreme Court. MouthShut.com versus Union of India. It's on April 10th, and I hope and I pray that we win. Thank you.
Thank you so much. I have to confess, I almost didn't want to stop you. Great perspective from the business end, and it couldn't get more stark than that. When you look at it, this issue in terms of extremes. I believe Mr. Mukul Sharma has one little comment to add. Mr. Sharma.
I tried to project an opinion that freedom of speech and expression is a fundamental right. It is available against the government primarily, and it is not really very clear as to whether it is available against the individuals or not. But one would expect, naive as he is, that if the freedom of speech and expression has been guaranteed by the Constitution, the government would do something to protect it when an individual is being targeted. Now, I have full sympathy with the CEO of MouthShut.com. It is very remarkable that when he publishes anything, he gets slapped with the notices demanding, shall we say, damages running to 200 or 2,000 crores of rupees. But there is something which can happen and which is even worse, and probably I would be adding to his nightmares. Because of its reach, every person can, at any place in India, open up on his laptop any given topic, and if he finds that any post by anyone anywhere is defamatory, he can file a complaint at the very place that he is sitting. Now, under the circumstances, potentially, against any post, hundreds and thousands of criminal complaints can be filed, and under these circumstances, the person who has hosted, the person who has published, and the person who has exercised his freedom of speech and expression would be completely swamped with complaints. He shall never be able to get out of that quagmire ever again in his life. And therefore, it is urgently necessary that there has to be some legislative measure to ensure that if somebody wants to prosecute somebody for a post made on the internet, then he should have only one place and one jurisdiction, and that should apply to everyone across the country. Otherwise, the things will become totally unimaginably worse for anyone who wants to publish anything on the internet.
So even though we've had a very brief, and then, where all the speakers have unfortunately had to curtail, their time, I think the perspectives were great from a constitutional development perspective, the problems with the Information Technology Act, the business end of, how the law has developed and meant, and the consequences. I'd like to thank all the speakers. I don't think we have time for a Q&A, so maybe one or two questions at the most. So if anybody has any questions, don't be shy, put your hand up and ask. I think that brief session kind of crunched it all in, and there's complete enlightenment. So I think we can break for more important business now. Thank you.
Thank you very much, sir. And thank you very much for limiting this entire conversation in our time. Thank you very much, Mr. Ameet Datta, Mr. Mukul Sharma, Mr. Faisal Farooqui, and Dr. Raman Mittal. Thank you very much, and thank you all for being here. May I, before we call it a day, I would request Mrs. Chitrita Chatterjee from IAMAI to please felicitate our esteemed guests. Mr. Ameet Datta, Mr. Mukul Sharma, Mr. Faisal Farooqui, and Dr. Raman Mittal.